Okay, today is Monday, August 5th, 2013. This is a statement for settlement conference in Stockton, California, Administrative Judge Grill. This is Julio Zamora, 1385 El Camino Way, Los Banos, California, 93635. I was hired at Safeway in 2002. I received a notice of offer of work on December 1st, 2010. They on the 5th day of work on December 7th, 2010, they just sent me home with nothing in writing, what, where, who, or anything, or suspension or discharge, nothing when they sent me home. They just flat out sent me home. Okay, today is July 9, 2013. This is a statement under oath for Workmen's Comp Settlement Conference in Stockton, California for Administrative Judge Grill hearing. I was hired in 2002. At that time, I bought a lifetime medical plan. I paid $2,000 to $3,000 plus, and I could retire anytime after 2 or 3 years. Okay, so anyway, this is all about a disability, hearing impairment, and I have a permanent disability according to QME report. That was I took a QME report, a physical on October 1st, 2010. On October 1st, 2010, the doctor said he doesn't do hearing. And so at that time, the QME report wasn't complete, but yet he made out a QME report. And I received it on December 1st along with a notice of offer of work. Good for 1 year, which I asked for the 10 o'clock Eureka run in the morning, which I didn't start 1 day on. On the notice of offer of work was sent by Espinoza, Safeway Insurance in Arizona, okay, claim adjuster. I received it on December 1st, 2010. On December 3rd, 2010, I went to work. On December 7th, 2010, they just sent me home. Nothing in writing, who, what, where, when, and why, nothing. And Safeway is a union shop. They're under a contract. They're supposed to work me first, grieve later. It didn't happen. I was supposed to have representation upon interrogation on December 7th, 2010. It didn't happen. He told me to sit down, and a shop steward's on his way. I had a second interrogation by Mike Sadler, safety manager. He didn't have any statement from the dispatcher who made the false accusations. He just had a letter in his hand that he posted some time back, which I don't recall what it was about or anything else. I was just totally, I was surprised. I went to work and this guy came at me and I was just totally surprised. I didn't know what the heck was going on. So after the shop steward came, we went in to see Mike Sadler. And he had the posting in his hand. Statement wasn't even wrote up yet. He asked for my seniority. Shop steward said it's a safety issue and he's going to look into it. He asked for my security badge, and then he had the shop steward send me home. Didn't allow me to clock out or anything else. We have 2 time clocks. We have a trip sheet that belongs to the tractor. We're under Department of Transportation regulation. When we log out of that tractor, we're supposed to go home, according to the regulation, but we're not allowed to do so. We have to clock out in the driver's room, clock in and out. I should note for one thing that we bid every 6 months, automatic start every morning. I have to be there at 10:30. Automatic start, I'm already on duty at 10:30 in the morning. So in any event, the dispatcher on December 6, 2010, falsified my logs by changing the time, taking the time from the second time clock and changing the time on my logs. Now, why he did that, I don't know, but that's what he did. In doing so, he put me in violation of the Department of Transportation and company policy. And me, myself, and 400 other truck drivers follow company policy. You will follow Department of Transportation regulation. You will follow the DOT regulation, and that's what we all do. And we also have a no fault attendance policy that is part of company policy that we've had for the last 10 or 20 years. So what his reason is, I don't know, and why he took the time off the second time clock, I have no idea. I haven't been paid by that second time clock in 10 years. There's no time card. If I run out of miles or hours, and I'm in Livermore or somewhere, I'm supposed to log out. According to the regulation, I'm supposed to go home. But that's not the case. They send a pickup truck and they pick me up, and then I drive back and clock out on the company time clock. And it's not being recorded. It's not being recorded. We only get paid by the trip miles. That's it. It doesn't show anything else on the log unless they alter it. They're not allowed to do so unless they make the driver aware in the remarks section what the problem is. It wasn't done. So any event on December 6th, that's what he did. On December 7th, 2010, that to much of my surprise, I walked into something, and I have no idea what I walked into because I had no representation. He told me to sit down. The shop steward's on his way. At that time, I had a notice of offer of work that I received on December 1st, 2010. And then when I went to work on December 3rd, 2010, on the 5th day of work, when I was going to turn it in, I was sent home. So in any event, Mike said I was looking into it, and he sent me home, and I'm sitting here waiting for registered mail or a phone call due to the fact that I'm supposed to work first and grieve later. It didn't happen. And I didn't get anything in writing stating why or who or what, whatever. Nothing in writing. Okay, not by registered mail or anything else, not even a Board of Adjustments. I should note that if no registered mail or nothing in writing is received within 10 days, the issues are dropped. Null and void, final and binding. Issues are dropped. They didn't respond within 10 days to produce evidence or documents to show what my disciplinary action is. And on December 17th, the BA Mike Nicewanger, Mr. Nicewanger, sent James Williams, the transportation manager, a letter asking for him to set a date and time to have a panel hearing. And he set it for January 11, 2011. That's more than 30 days. In any event, long story short, they didn't accommodate me at any time. The panel hearing, they just sent me home, and I told them I had a severe, profound hearing impairment, and I asked them if they were an authority. There was no reply. Mr. Nicewanger was there, the BA from Local 439 in Stockton, California. They just flat out sent me home. I asked for arbitration from the union attorney, and I sent him a prescription and the test results for severe, profound hearing impairment. He ignored it, and he denied me arbitration. And he put it on Workmen's Comp, stating in the letter that he's aware I have disability issues. And he laid it on Workmen's Comp to resolve these issues. Now, why he did that, I don't know, but that's what he did, and that's what happened. And come to find out, Judge Grill had to order a report, a legal document for severe, profound hearing impairment. And I should note that I received a copy of that, and it states that I've had a hearing problem since 2006. I've had a hearing problem, and I haven't been accommodated all that time. So there are disability issues. The union is aware of the fact that I have disability issues, and there's no doubt about it. Yet they don't want to deal with the situation. They laid it on Workmen's Comp to return me to work because I'm supposed to work first and grieve later. It didn't happen, and they didn't file within 10 days They didn't produce any documents, so I should get all back pay and benefits, RSVP, lifetime medical, uh, behind the notice of offer of work. I should note that there's over 400 truck drivers there, and we all work 14 hours a day, and that there's no time card on the second time clock. So there's no, I've never been paid in the last 10 years. So how the judge wants to handle this, I don't know. But in any event, I need a court order to get my back pay at 14 hours a day from December 7th until I'm returned to work, till they enforce a notice of offer of work. Due to the fact that Esperanza Safeway Insurance in Arizona sent me a notice of offer of work, like I said before. I received a second notice of offer of work from MORLES Claim Adjuster, Phoenix, Arizona. The attorney sent me a letter to report to work, and Mike Sadler says he doesn't know anything about it, and the union didn't take any action. So I'm sitting here waiting for a phone call or registered mail to be returned to work, and it didn't happen. So what the judge wants to do about that, I don't know. But the fact is that they didn't pay my health and welfare. They stopped paying my health and welfare and my lifetime medical plan, which is a premium. When I retire, which I could retire at any time, I don't pay any premium when I retire. I don't pay any payments. Okay? So I need that notice of offer of work enforced to be returned to work. I need that 1 year or longer if I can get it. But I need protection from the court, and I need a court order in order to get all back pay at 14 hours a day. Otherwise, it's not going to happen. So just one thing, I just want to clear up the fact that I went to the department, to the Highway Patrol office, and I took my logs there and had him look at it, and my wife was there. He said that it appeared that all logs were tampered or altered with. Tampered or altered with. And the dispatcher is the only one with the key to be able to do that. Okay? And he didn't make me aware on December 7th what he did. He just falsified my documents and put me in violation of company policy and DOT regulation. And I received a notice of offer of work on December 1st, 2010, like I said, and on December 7th, 2010, he just flat out sent me home. He falsified my documents, and he didn't allow me representation. He told me to sit down. The sheriff's steward's on his way. And then Mike Sadler asked for my seniority on the second interrogation, and the sheriff's steward was there, and he said it was a safety issue, which was ignored, and he's going to look into it, and I haven't been notified since. I was sent home with nothing in writing, and no time limits were met, so it's null and void binding, and all issues are dropped. So I'm sitting here waiting for a phone call or registered mail to report to work according to the notice of offer of work. It hasn't been done. So, and I should note, that's two. Two claim adjusters sent me a notice of offer of work. And the attorney sent me a letter report, and like I said before, it wasn't honored. So, I'd just like the Administrative Judge Gill to be aware of that, and the fact that the union should be held responsible because of my disability issues and a hearing impairment, and they didn't accommodate me at any time. And Safeway never produced any documents or anything in writing showing what my disciplinary matter is or what it was or anything else. And they didn't file within the time limits. And on December 17, 2010, Mike Sadler filed a grievance. It was received by Local 439 and Stockton, California Teamsters, a grievance, which was more than 10 days. And James Williams, the transportation manager, set a time and date for January 11, 2011. That's more than 30 days. And he was also asked to produce all evidence and documents by December 25th, 2010. It didn't happen. He didn't produce anything. So all issues are dropped, final and binding, null and void. There are no issues. So on December 7, 2010, he just sent me home after I received the notice of offer of work on December 1st, 2010. Now, going on from there, Adam Stewart didn't put on anything on Administrative Judge Grill's desk on the first settlement conference hearing. He didn't put the notice of offer of work on his desk. He didn't put the severe profound hearing impairment on his desk. Judge Grill had to order for the two attorneys to get a legal document, which they did, and he's probably has the legal document, which I have a copy, which states that I've had a hearing problem since 2006, and I haven't been accommodated. So again, the notice of offer of work needs to be enforced. If it at all possible, if Judge Grill can take that into consideration, I would appreciate it.
Today is Sunday, March 3rd, 2013. Another notation for the record for court. The fact is, I took a QME report in October, and in the QME report, it states the fact that he doesn't do hearing tests, and the QME report wasn't complete, and that Adam Stewart didn't send me to a hearing doctor to have a hearing test, and the fact that he wrote down that I had a permanent disability and how much it was, and the fact that I filed that I had a hearing impairment in 2009, and when I went to settlement conference, nothing was on the table for Judge Grill. The QME report wasn't complete. The severe profound hearing impairment wasn't on his table. And the fact is that, like I said before, they just flat out sent me home, and the QME report wasn't finished. And I didn't do anything wrong. I'm innocent. And the fact that they called up and the Health and Welfare Department and said I didn't work there anymore was a mistake. Because I paid for that lifetime medical, and I could have retired any time after 2003 or 4. I could have retired at any time and had lifetime medical with no premium. And I have a disability, and in fact, I didn't realize how severe my hearing impairment was. So they need to honor the notice of offer of work. They knew I had a QME report that I had a permanent disability and that I was on FMLA, and the QME report wasn't complete. And they just flat out sent me home and then said that I was fired on December 16, 2010, the union attorney, when in fact they didn't follow contractual procedures. And most important of all, they didn't notify me that I was suspended or fired or anything else. They just flat out sent me home. I can assume anything at that point, but I didn't. Because I have 200 employees underneath me and I didn't do anything wrong, and I have a permanent disability. In fact, on top of that, when the QME report was complete, I should note that for the record, that I'm deaf. I have a hearing impairment. And according to the 2009 Disability Act, which I'm protected under by the federal government, for people with hearing impairment. So, and I don't know what the workman's comp rules are, or if the Disability Act applies in this situation. So that's why I'm requesting to go to trial. And I'm also requesting that Mr. or Mrs. MORLES replace my lifetime medical immediately by court order. For the fact that Safeway called up and and I don't have no lifetime medical for myself or my family, or to cure or relieve pain and suffering from the on the job injury. So and I'm guaranteed that 1 year, and I need that 1 year. So again, the reason for the notation is the fact that the QME report was not complete, and it states in the QME report that he doesn't do hearing tests. So Adam Stewart was required to send me to a hearing to get a legal document, which he didn't do in October, when the QME stated and made a statement in the QME report the fact that he doesn't do hearing tests. So that's all I want to make a notation to the court, and I need to remember that to bring it up to Judge Grill in the settlement conference. A request for trial that the QME report was not complete, and it states in there that he doesn't do hearing tests. But the fact is, he did state I have a permanent disability, and I could do my job. Okay, so and in fact that that when they were aware of this, they just flat out sent me home. There's no need to go into the dispatcher or anything else. There's no doubt that that man is guilty. And there's no doubt that the fact that they had a no fault attendance policy for maybe 30 years, 40 years, who knows, but they've had it for such a long time, it's just unbelievable. No fault attendance policy. So, so I'm innocent. There's no doubt about the fact that I'm innocent. They sent me home because I have a disability.
And I'd like to note one thing, that on the second interrogation with Mike Sadler and the shop steward was there, the fact is that the dispatcher didn't even make a report out. He didn't even make a report out what my disciplinary matter is. Mike Sadler just assumed that I knew about the posting on the bulletin board. He made an assumption. There was no investigation. There wasn't anything. He just assumed that I knew about the posting, which I didn't. I told him, I don't know what you're talking about. And he asked for my seniority. Now, why he did that, I don't know. And I said it repeatedly. I don't know what you're talking about. I didn't falsify anything. But he assumed, he took it upon himself and assumed that I was guilty, and took my security badge and had the shop steward send me home, without no investigation or no evidence or anything else, and nothing in writing, and sent me home just like that, with nothing in writing. Just sent me home and said I was going to look into it. Okay, and and according to the contract, he's supposed to work me first and grieve later. So it's wrong. What he did was wrong. He shouldn't have sent me home. He should have worked me first and grieve later. Okay? Again, I like the Administrative Judge Grill to realize the fact that there was no report made out by the dispatcher what my disciplinary matter is to be, or what it is. He just made an assumption off the bulletin board and pronounced me guilty without having a hearing or representation whatsoever. So I'd like to note that to Administrative Judge Grill to take that into consideration.
And I have a hearing impairment. There's no doubt about that, because the QME report is now complete. And when I go to the settlement conference, when I get my court date, I'm going to make that statement under oath. And I'll have a notice of offer of work. I'll have a legal document that I'm deaf, that I have a hearing impairment, and that I should be returned to work according to the notice of offer of work that is supported by a QME report from October, and the fact that Adam Stewart didn't put all that on Judge Grill's desk, so I'm asking for enforcement of that notice of offer of work, and whatever I asked for in my other statement. But the point is, not to make a long story, a short story into a long story, which I'm rattling on, because I do have a profound hearing impairment, and it's really bad. It's really bad. My wife is irritated, and I'm talking really loud, and it's just, I need to be returned to work. I can do my job. I don't have a problem doing my job or going to work or anything else. I need that 1 year, and it's very important. I shouldn't be denied that 1 year, no matter what. So I'm going to ask Judge Grill if he could do that, and if the union was correct in sending me home and not accommodating me with a listening device at the panel hearing, when they just flat out sent me home and didn't finish the panel hearing. So that's why I need to go to trial. That issue and the fact that my lifetime medical insurance, that's also an issue, needs to be resolved by the court, by Superior Court or the workman comp judge. I need to go to trial. Because it's not right. I informed the union that I had a severe profound hearing impairment, and they made the statement the fact that they were aware of it and I had disability issues. And the fact that they just flat out sent me home and didn't finish to complete the panel hearing, let alone produce any evidence why or why not did they send me home. They just flat out sent me home. Nothing in writing or that I was suspended or anything else. They just didn't do anything. And I don't even know why I'm sitting at home. Why am I sitting here? I don't have any documents that states why I'm not working. Not one but registered mail or time limits. Not one document explaining to me why I'm sitting here waiting for a phone call or registered mail to report to work. And it's going on 3 years. I don't have one document. Not one. So I should get paid. From December 7, 2010, there's no doubt about it. I should get paid. This is just nothing but harassment. And it could be retaliation. I don't know. That's why I need to go to trial. I need to find out why this is all happening. I wasn't informed by the time limits or any other thing. No registered mail, not one. You know, not even a Dear John letter, nothing. And I haven't been able to get treatment or anything else. And I've had to pay for my own payment with my acupuncture, and I can't get her as an acupuncture for my treating physician because her name is not on the HMO list. So I gotta go to this other one, and I really don't want to because I've been treated by this other lady for so long. I don't want to start all over again. It's crazy. So I'm gonna have to wait until I go to trial and try to, get by. But I need to return to work. If I can just get to work and get my back pay, I can get my own organic medicine, whatever it is, and take care of myself until I get my lifetime medical. And then I can go in and get my pinched nerve fixed because I got medical insurance for life. And I'm being denied the right to get my disability fixed or cured or relieved from any stress or pain from the on-the-job injury because of their actions. And like I said before, I don't have one document of why I'm sitting here. Not one. I have no registered mail, not one, not one registered mail. Never mind with Nicewanger, he's not Safeway. He's the union. They don't have the right to say I'm fired or I'm being disciplined or anything else. Safeway needs to inform me of what's going on, not the union. And the union didn't do anything. I mean, I had to wait till 2011 to actually find out what the heck is going on because there was nothing showed to me or registered mail of what this was all about. That's insane. And I have a permanent disability. Nothing was put even on Judge Grill's desk. He don't even know what's going on. So, I don't know. I need to go to trial. And I need my lifetime medical returned immediately. That Safeway private insurance in Arizona needs to replace that lifetime medical. So I'm going to request that in court, that they return that lifetime medical, because there's no reason why I should not be covered with lifetime medical that I paid for in 2003. And I could have retired any time after that. I could have retired. I'm qualified to retire now. But I need that 1 year. They offered it. It's an agreement. So I need to go to trial, because I'm being persecuted and I'm being sitting here, and it's really hard. I'm a good worker. I didn't do anything wrong. You know, it's just not fair. I'm dragging on with this notation again. I wish I could stop repeating myself over and over and over again. And they need to accommodate me with some hearing aids. I gotta tell you, I bought the first pair, but they're not right. They don't block out background noise or static or this and that, you know. And I gotta also remind myself, on December 7th, 2010, that dispatcher, he was loud. I don't know what he said, but he was loud. I had to step back because he was waving his hands and this, and all this. I didn't know what the hell he was talking about. I mean, the guy was just frantic. I mean, Jesus Christ, man. I really walked into it on that day. And I did my work. I didn't do anything wrong. You know, I mean, there was no need for all of that. Raising your hands and just bragging to everybody how I got Julio's. Got what? I got nothing in writing, nothing stating why this or that or anything else. So I was falsely accused of whatever it is. I was falsely accused. I know I found out something in January 2011 when they said the panel day, which they shouldn't have. I should have went to Board of Adjustment. But even then, what was I going to Board of Adjustment for? I don't even know. I don't even know what this disciplinary matter really is, because I was never notified, and they never produced one document of what the disciplinary action was about. Not one. And the fact that they didn't meet the time limits like they do for 1,500 other Teamsters and put them back to work, there was no reason why they shouldn't put me back to work. And James Williams, the transportation manager, it falls on his lap, because he's responsible. He's oversight for Mike Sadler and the rest of the transportation department. So I'm not going to make any accusations in that respect, because I'm going to let the judge do it. Let him decide what's correct, and let him tell me why was I sent home on December 7, 2010. I received a notice of offer on December 1st, okay? On the 3rd, I went to work. On the 5th day of work, he just flat out sent me home. And the rest is history. And the QME report wasn't finished yet, but yet they offered me a year worth of work, and the QME report wasn't even finished. It wasn't complete. So, I don't know. I'm looking into this thing going on 3 years, trying to figure out, because I'm innocent. I'm fighting back. And, I just don't get it, man. I don't feel guilt-ridden. I don't feel guilty about anything. I just don't get it. And I can't figure out why they shouldn't pay me back pay. I'd sure like to know why they shouldn't. They didn't notify me of anything. They have no excuse why not. And even though I can't get employment because of the state actions of the dispatcher and their state actions,
it still wouldn't matter anyway because I didn't do anything wrong. I have to sit here and wait to be called for work. It's true. Because if I'm not available when they call or call back, when they call me for work, they can fire me. So I wasn't notified. I was sent home. I gotta sit here and wait. I wasn't notified. The QME report wasn't finished. They knew I had a permanent disability and a hearing problem. They do all of the above. And I knew nothing of the below. So now I'm sitting here waiting to go to trial. And I gotta tell Judge Bill, I need to go to trial. This needs to be heard in trial and find out if they're guilty or not. And I need my lifetime medical and notice of offer of work to be enforced, and I'm to be allowed to report to work one way or the other. Because they don't comply. They don't comply, obviously. 3 times they didn't comply. They didn't comply with the contract. They didn't follow contractual procedures. They didn't follow the administrative judge suggestion. And I have a witness to that. And they didn't comply when the union attorney sent me to work. They didn't comply then either. And I guess they're not complying with the private insurance company Safeway in Arizona. So that could be 4 times. They're just not complying. The insurance company is telling my attorney, okay, I see the company offered you work for 1 year. Okay, go ahead and send this guy to work. Well, so what's going on? Well, I'm not working. Why wasn't I working then? They shouldn't have sent me home. They should have completed the QME report before they sent me home. Okay? So they don't complete the QME report. They send me home, and then on the 16th, the union attorney with no evidence, nothing whatsoever in his hand, and knowing about the fact that I have a hearing impairment.
And the fact that they're supposed to work me first and grieve later, and the union attorney didn't even mention that fact. They're supposed to work me first and grieve later. I should have been working all this time, but I wasn't working.
Decides not to follow contractual procedures with no evidence. Not one point did he state why I'm staying home, and I was notified according to contractual procedures. Now, I'm not accusing the attorney of not following his own contract or arrangement with local 439. I'm going to let the judge do that. It's really something, huh? An attorney. Lot to be said about that in court. So I guess we'll find out when we have discovery. And I don't know. My kid's life is at risk. My wife is sick, and I'm going through all this. And there's nothing in writing. I received nothing in writing of why. That I have to sit here and wait for a phone call or registered mail to report to work. And why, not one good reason why that I lost my lifetime medical that I paid for or contribute to. I paid 5 years ahead. They called up Health and Welfare because I called them and they said, no, you don't work there anymore. So I lost it. They need to replace it. Safeway private insurance company needs to replace my lifetime medical insurance. For the fact that on December 7, 2010, or in October when they made the QME report and the doctor says I don't do hearing, the QME report was not complete at that point. And the fact that they took it upon themselves to send me home with a permanent disability and the QME report not being complete, and the union attorney not allowing me to go to arbitration or finish the panel hearing regarding the QME report not being complete, or having me sent to a hearing specialist to find out if I'm telling the truth, he got the cart before the horse. And not even the union attorney can produce anything that, why I was sent home. It's just garbage. It's useless. The statements are useless. They have nothing to back it up with. Because they didn't send it within the time limit. So their statements or anything that they say is null and void. So, they don't have any grounds. Because according to state law, my assumption is they have to give me something in writing or let me know why they sent me home. They gotta tell me something. They gotta notify me. I don't see anything in the law that says they can take my lifetime medical away. Just flat out send me home and accuse me of making false accusations that they can't back up. Did an injustice occur? I'm sure it did. So we're gonna find out in discovery exactly why am I sitting here? And is it proper? Okay, I should get all my money back. And my money back and plus whatever the Disability Act calls for. So, I'm asking for trial, and I need to note this and make sure I bring it up to Judge Bill, the fact that Adam Stewart didn't put anything on the table. The fact that I wasn't notified at any time, place, or anything else of why I was sent home, nothing in writing. In fact, when they sent the letter to me from the union attorney to my attorney that I was discharged on December 16, 2010, they didn't state why. Didn't make one statement on why or any evidence or the fact that I was handed something in writing according to the contract when they sent me home of why I was being sent home and required to go to Board of Adjustments within 30 days of time of incident. No documents to show why I was sent home within the time limit. Nothing in writing. Not one thing. It's just gossip. Those are the facts. So, there's no evidence. There's nothing. They didn't give me anything which is required. And they just went ahead and did whatever they wanted to do without following the rules and regulations and contractual procedure. And they didn't follow workmen's comp rules and regulations. There's no doubt about it because the QME report wasn't finished and they went ahead and fired me while I was on disability and I had a severe and profound hearing impairment. And there was no reason why they sent me home before December 16, 2010 because I wasn't fired on December 7, 2010. And I wasn't disciplined for December 6, 2010 because there's nothing in writing. I didn't receive any registered mail or intent to discharge or suspend. Not one thing. And they had no right taking my lifetime medical away, which they have to replace. I'm asking the judge to have it replaced court order. So it seems to me that everything has to be a court order. And I guess it's just a superior court to close them down because they can't operate without insurance. And if they don't comply, that's cause. All they have to do is show cause. That's all the judge has to do is show cause and cancel their insurance. Safeway Incorporated. So, I can show cause that I shouldn't have been sent home. And upon discovery, I'm sure it's going to come out the fact that yes, I wasn't notified or intent to discharge or suspend. Nothing in writing, just false accusations and nothing to back it up. And I would assume that the union attorney made a mistake because he acted without cause, without justification, without no evidence, within the time limits, within contractual procedure. The union attorney, it's not for me to say, but that'll be for the judge to say. So, and the fact that Mike Niceworthy didn't complete the final hearing, that's another one that the judge will have to take into account under the Disability Act of 2009. Because the unions or anyone else are not allowed to discriminate against the people with hearing impairment. And so, the union is protected, but not under the Disability Act of 2009. So, the union is not taking any steps to get me back to work, and they have nothing in writing or statements within the time limit of why, or who, what, where, and when. And then they had the right to send me home even though the QME report was not complete. And I gave them a copy of the severe profound hearing impairment to complete the QME report, and they didn't take it serious. They just didn't do anything. And they didn't do nothing within the time limits, and they didn't produce any evidence by December 25th, 2010, within 10 days. From December 17th to December 25th, I should say they gave it till the 25th, but they didn't reply in 10, 20, or 30 days with any evidence or anything of that I'm guilty or what the reason is why they sent me home. Not one document within the time limit. They didn't respond within 30 days. That's what I'm talking about. There's no evidence to show cause. So, there I go rattling on. Oh man, I need to get back to work. So anyway, I'm asking for trial. So, I guess that's it. I gotta know, remember this notation was about the fact that the QME was not complete. And the fact that the QME, the doctor said he doesn't do hearing. So there was Adam Stewart's responsibility to get me a hearing test. To complete the QME report, the fact that it said I had a permanent disability, but I don't do hearing tests. So they had no right to send me home on December 7, 2010. And they didn't show cause or anything else why. And I don't know, they're required to do so under the contract. But I don't know state law completely. So that's why we need to go to trial to decide if I'm guilty or innocent, and if they discriminated against me underneath the Disability Act of 2009 for the hearing impaired. So, I gotta remind myself before I go to court, I'm waiting for my court date, or a phone call or registered mail. And, that's my notation, that's what I come up with. I guess I had a nightmare last night, huh?
Well, I'd like to mention one thing to the Administrative Judge Grill, settlement conference in Stockton, California. The fact that Mike Settler assumed that I was guilty. He didn't even have a statement from the dispatcher. I know I'm repeating myself, but the fact is, he asked for my seniority. He took the sole responsibility of sending me home without any evidence or anything else. Okay, and I told him I didn't know what he was talking about. I don't understand what you're talking about. And you know what? I must have been on disability. Maybe I was on disability. I don't know. It's been such a long time now already. But the fact is, he shouldn't have played judge. He should have had an investigation. He should have found out if I was guilty or not. You know, because there's 2 time clocks there, you know. And the second time clock, I haven't been paid in the last 10 years. And I work 14 hours a day, and I get a trip sheet. I get paid by the mile, me and 400 other truck drivers. We haven't been paid in years by that second time clock. Okay, if we run out of hours or miles out down there in Livermore or something like that, we got to drive a truck back and clock out on that second time clock. We're not getting paid by the hour. Now, he assumes that he can do that. And he does that, and then right after I have interrogation by the dispatcher, and I have no representation, and he's making false accusation, and doesn't make me aware of what he did on December 6, 2010. He did not make me aware that he altered or falsified my laws, and he's not supposed to do that. But he took it upon himself to do it. Okay, that was fine. He told me to sit down, the shop steward's on his way. And then as soon as the shop steward gets there, I go right into Max Sadler's office, and dispatcher hasn't even wrote up the investigative report or anything else. Mike Sadler didn't have anything in his hand. Only thing he had, I guess he wanted me to sign something, but I'm not signing anything because it's not true. I don't know what he's talking about. Okay? So, and then he asked for my seniority, and I don't even know what that's about. So they sent me home with nothing in writing. They violated the contract, worked first, leave later, and I should get paid 14 hours a day, like 400 other truck drivers. They get paid 14 hours a day. I should get paid by the hour, 14 hours a day, just like everybody else. Now, why we have 2 time clocks and the other employees, the 1,000 employees, only have 1 time clock, I don't know. But I haven't been paid in the last 10 years by that second time clock. So that's for the judge to decide what my back pay should be at 14 hours a day. So, and I'd like Judge Grill to consider the fact that a double standard is the application of different sets of principles for a familiar situation or 2 different people in the same situation. A double standard may take the form of an instance in which certain concepts, often, for example, a word, phrase, social norm, or rule, are perceived as acceptable to be applied by one group of people, but are considered unacceptable, taboo, when applied by another group. The concept of double standards has long been applied as early as 1872 to different moral structure on men versus women. A double standard, thus, can be described as a sort of bias, morality, unfair suspension towards a certain group of the principle that all are equal in their freedoms. Such double standards are seen as unjustified because they violate a basic maxim of modern legal jurisprudence, that all parties should stand equal before the law. Double standards also violate the principle of justice, known as impartiality, which is based on the assumption that the same standard should be applied to all people without regard to subjective bias or favoritism based on social class, rank, ethnicity, gender, religion, sexual orientation, age, or other distinctions. A double standard violates this principle by holding different people accountable according to different standards. The phrase "life is not fair" may be invoked in order to mollify concerns over double standards. I, Julio Zamora, invoke double standards. Life is not fair. And I hope that Judge Grill considers this, sending this case to trial in the interest of justice. I'd like to know one thing, the fact that on December 17th, Mr. Niswonger sent James Williams a letter stating to set a date for a panel hearing and to produce all evidence, documents, and photos by December 25th. No later than December 26th from December 6th, within 10 days. They didn't produce anything. And I'd like Administrative Judge Grill to consider that any documents that Safeway presents or the insurance company presents, whatever it may be, if it's not dated before December 26th, not to be accepted. Due to the fact that we have 1,500 employees there, if it's not within 10 days, it's null and void, final and binding. All issues are dropped. There are no issues. Now, if those 1,500 employees are put back to work because it's not within the 10-day time limits of the contract, which is an agreement made with Safeway with Local 439, International Brotherhood of Teamsters, if it's not within 10 days, it's not accepted, and the individual is put back to work immediately. So I'm asking Judge Grill, Administrative Judge Grill, not to accept any documents if they're not if they're not dated before December 26th, okay, that's within 10 days. They didn't do so, and they should have put me back to work like 1,500 other Teamsters. Okay? And as far as the second time clock is concerned, when they pick us up someplace or anything, we're supposed to write the delay on the trip sheet. But the fact is that when we log out of that truck, we're off duty. The time, we should get paid by the hour, okay? And the time isn't being recorded, so, and there's no time card. So when we put the delay down on the trip sheet, and mind you, we're not, and it's not being recorded, not the miles or the delay or anything else being recorded on the logs. So there's no way of proving that we even got paid that delay from Livermore or Dublin, or when I ran out of hours in Eureka and I was at 70 hours. I never got paid for that, and it probably doesn't even show. I mean, you know, because it's on the trip sheet. We should be paid by the hour. When I went from Eureka back to Tracy, California, I should have been paid by the hour. But no, I was in that truck, and I was off duty, and they picked me up. Okay? And I never got paid. And it's not even being recorded because I was off duty. I should have been being paid by the hour, and I was in violation. No, I can't do two things at once. Follow DOT regulation and then Jesus Christ, man, it's confusing, but it's not confusing. The fact is, I haven't been paid since 2002 by that second time clock. Okay? The delay goes on a trip sheet. The trip sheet goes with the tractor. DOT regulation. We get paid by what's being recorded on the logs, not by what's written down, but what's being recorded. We only get paid trip miles. They don't like to pay delay. They do and they don't. There's no record because it's not recorded on the logs. You can't write it in there. It's got to be recorded. And if anybody would to check that out, you could see it's going to be a mismatch. It's not going to add up, and it doesn't show that the employee ever got paid by the second time clock. Okay? That's two time clocks. Okay, you log out of that truck, you're off duty. You come to work, you're on duty automatically. You don't need a time clock to be on duty. You're already on duty. So I am asking Judge Villeneuve to accept any statements or any documents if it's not dated before December 26, 2010. So I'm asking Judge Grill to take that into consideration.
Okay, today is Tuesday, March 26, 2013. I want to make a notation for myself for trial. The fact that they didn't follow contractual procedures, that's one thing. Disciplinary action was denied, that was another thing, and they should have put me back to work like 1,500 Teamsters. I believe the reason they didn't put me back to work is because they don't deal with disability issues. I think that's what it is, because I sent up a prescription and the test results for hearing impairment. So they well aware of the fact that I have a hearing impairment, and they denied me arbitration. Because the union probably, the company, Safeway, doesn't want to put me to work because I have a disability. And they probably going to deal with it in workman's comp. So the union just went along with Safeway. But the fact is, the union doesn't realize, I believe, that the Disability Act of 2009 was amended, and it included unions. There are no laws that discriminate against people that have a hearing impairment. And I'm stating for the record that they did. They discriminated against me by not returning me to work like 1,500 other Teamsters, that if it's not filed in a timely manner, that it return to work immediately. Now, the fact that the union doesn't handle disability issues is incorrect. According to the Disability Act that was amended in 2009, which includes unions on the hearing impaired. So I'm sitting here waiting for a phone call or registered mail, and it hasn't been done.
due to the fact that James Williams, the transportation manager, didn't fulfill his responsibilities. So I'm saying that he knew all what's going on and he refused to comply with the Disability Act of 2009. So that's my statement for trial, and I believe that's what the problem is. The union will not deal with the hearing impaired, and Safeway will not put me to work because I have a disability. And the union is incorrect because they violated their contract by not working me first and grieve later and let these issues be resolved in a time. And the fact that Mike Taylor didn't file in a timely manner also shows that the fact that they don't want to put me to work because of my disability, and they don't want to honor the notice of offer of work, which is good for 1 year, and it needs to be enforced. So I'm stating for the record that Local 439 Teamsters in Stockton, California violated the Disability Act that was amended in 2009 for the hearing impaired. And that they're well aware of the issues, and they denied me arbitration. And when they did that, they violated the Disability Act of 2009 that was enacted by the United States Congress. So that's my statement. Okay, I'm just going to add this to the end of that recording. I'd like to remind the court the fact that when I was sent home on December 7, 2010, when I received the QME report on December 1st, 2010, it wasn't complete. The QME report was not complete because the doctor, I forgot his name, said that he doesn't do hearing tests. And I received that on December 1st, 2010. Like I said, a short story. I don't want to make a long story out of a short story. The fact is the QME report wasn't complete. They offered me work for 1 year, and I needed it enforced. Because the QME report wasn't finished yet. They just flat out sent me home. And I'm sitting here, and I don't know why I'm sitting here. They violated all the time limits. They didn't produce any evidence of what my disciplinary action is to be or what it was by December 25th. And at least they had to put something in by December 28th, within 10 days. They didn't do so. They didn't do anything. They went around the Board of Adjustments, and that has time limits within 30 days. They didn't do that. They just didn't do anything within the time limits. And I don't know why I'm sitting here waiting for a phone call or registered mail to report to work when I have 200 employees underneath me. Now, James Williams, the transportation manager in Tracy, California, knows all this. He should have returned me to work like he does for 1,500 other Teamsters or 400 truck drivers. If it's not within the time limits, they're returned to work immediately. If it's not within the time limits, they're returned to work immediately. Now, I should note for the record in Administrative Judge Grill the fact that I don't know why I'm sitting here. They didn't produce anything. I never received any registered mail whatsoever of any suspension or discharge within the time limits. I did not receive one document of why I'm sitting here waiting for a phone call or registered mail to return to work according to the notice of offer of work that I asked for Eureka Run at 10 o'clock in the morning. And I'm still sitting here waiting. So I should get all that back pay because they didn't comply. 3 times they didn't comply. And I hate to keep repeating myself, but my life is on the line here. And I don't know why I'm sitting here. I don't have one document. Not one document for suspension or discharge, or the reason why I'm sitting here by registered mail within the time limits. Not one. And I'm still sitting here. So I should get all that back paying benefits, and I hope Administrative Judge Grill returns me work according to the notice of offer of work that wasn't complete. They just flat out sent me home. And so I'm not going to go into it anymore about the deposition that I wasn't accommodated or anything else, and I need to take another deposition for the record. And that I have a new attorney, Modesto Legal Clinic, who took my case. Obviously, by my statement, you know why. The fact that Judge Grill didn't have nothing on the table, not my severe profound hearing impairment or the notice of offer of work. And that if it's at all possible, if Judge Grill could agree to the fact that Safeway should pay all attorney fees and expenses to Modesto Legal Clinic for all their hard work and getting me to be returned to work. For the fact that Adam Stewart, I feel that he failed in his responsibility by not getting me a hearing test or not mentioning the fact to the Administrative Judge Grill that the QME report was not complete, and I didn't get paid every week or every 2 weeks, and that they're in conflict of liability with the EDD, Department of Unemployment, and he didn't mention one word about it since 4/17/2009 and ongoing, and I received another document from EDD saying that Safeway is in conflict of liability. I should be working. So with that being said, and the fact that Safeway doesn't want to comply, and it's just more time and money for Modesto Legal Clinic, who's representing me. And I don't feel I should have to pay Adam Stewart anything. So, but that's for you to decide what is fair and equal under the law. And your decision, I agreed to accept your decision, whatever is reasonable under the law. But I do request to go to trial to hear the case for the 202 Disability Act of 2009. Anyways, like I said, I have permission, or I was instructed to pursue this by the union attorney on workman's comp, and they're aware that I have a disability issues. I exhausted the union remedy. There's no remedy under the union to return me to work because I have a disability. And so they're not going to deal with it, and they threw it on workman's comp's lap. So, and the fact that I told them that I had a severe profound hearing impairment, and that wasn't acceptable, even though I sent them a prescription, and the test results to the union attorney, and it wasn't accepted, and they denied me arbitration. And so I, Julio Zamora, invoke double standards. Life is not fair. Okay, today is Friday, March 1st. Making a statement for Judge Grill Settlement Conference in Stockton, California. On 3/21/2009, I was injured on the job, and I went to see Nancy Perdillo, and she stated that it was a sprain. I don't recall going to the hospital or an MRI being taken at that time. And she's an alcohol and drug technician, which gives you tests to see if you were on drugs or alcohol at the time of injury. And there was no doctor present. On maybe a week or 2 weeks later, I ended up in the Los Banos Memorial Hospital with severe pain. It was really, really bad. I couldn't take it anymore. So I was there all night long, and they took an MRI and discovered the fact that I had a pinched nerve. They took an MRI the next day. I went in there for left leg pain, the same thing I'd seen Nancy Perdillo for in Tracy, California. Drug and alcohol technician who said it was a sprain. Now, I'm not going to go into the PR2 report because it's incorrect and it wasn't completely signed properly. And the fact is, I had a treating physician that I signed for good for 1 year, Paralosi, chiropractor. That if I get hurt on a job, that I'm to go to the company doctor for 30 days, and then the chiropractor is to take over. Okay, so and the Los Angeles Memorial Hospital made out an occupational report stating the fact that I went in there for left leg pain, and that I have a low back, a pinched nerve. And I don't remember who I got the referral from, if it's Los Angeles Memorial Hospital, what doctor it was, or if it was Dr. Yip or Perlosi. But they gave me a referral to Dr. Baby, and to fix the pinched nerve, it's a walk in and walk out type deal. And I was denied by Safeway, and they sent the letter to the wrong person, to Dr. Hubby, asking her if it was job related, the pinched nerve. And they should have sent it to Nancy Perdillo, the drug and alcohol technician, but they didn't do so because she's the one that said it was a sprain. So, okay, I haven't been paid every week or every 2 weeks, disability payments. Since I would say since 3/21/2009 or 4/17/2009. I had to file for unemployment, and they sent me a letter stating that Safeway was in conflict of liability, and they sent me another one in 2012 or 2013 that Safeway is in conflict of liability. I should note that I have a notice of offer of work that I received on December 1st. December 3rd, I went to work. On December 7, 2010, they flat out sent me home. Just flat out sent me home. I had no representation. And the fact is, I was supposed to work first and grieve later. That didn't happen. They just flat out sent me home, and they made false accusations. And this is all disability related due to the fact that I filed in 2009 severe and profound hearing impairment from reefer noise. Come to find out, at the settlement conference, Judge Bill's court suggested that I get a legal document for severe and profound hearing impairment, and come to find out that I've had a hearing problem since 2006. I needed to be accommodated with a listening device because I have more than a 50% hearing loss in both ears. And I should note also, for the record, since 2006, I have never been accommodated with any sort of listening device or hearing aids or anything else for that matter. It wasn't taken serious by the union or the company. But due to the fact that they had a panel hearing, and they flat out sent me home when I mentioned the fact that I had a severe profound hearing impairment, and I asked the shop steward, "Are you an authority on severe profound hearing impairment?" And Mr. Niswanger, the BA from the local 439 Teamsters in Stockton, California, which is a union shop, was there also, plus another shop steward was there when I made that statement. And he said he's going to look into it, and they just flat out sent me home and didn't accommodate me. And I should also note the fact that Safeway didn't follow contractual procedures. I was denied to return to work because they didn't comply with the time limits, like they do for 1,500 other Teamsters, or return to work immediately if they violate the time limits. They didn't do so. I should also note that they're required to go to Board of Adjustments for all suspension and discharges within 30 days. I should note that on December 17, 2010, Mr. Niswanger sent a letter to the terminal manager, James Williams, that all disciplinary action to be denied, and to send all proof, photos, evidence, whatever you have, by December 25th, to establish a fact beyond a reasonable doubt that Mr. Zamora did wrong or deserved disciplinary actions, and to set a time and date. Well, the terminal manager, James Williams, did not comply. He set a date for January 11, 2011. I should note that's not within 30 days, according to the contract, all Board of Adjustment suspension and discharges are to be heard within 30 days of date of incident. And they didn't comply with time limits or anything else for the record. And on top of that, I was never notified that I was ever discharged by registered mail. I was never notified that I was ever fired, discharged, or suspended by registered mail, according to time limits. Okay? And so going from there, they didn't honor the notice of offer of work. They didn't apply, even though they made an agreement with Workmen's Comp to work me for 1 year. And it was deemed accepted, whether I turned it in or not, and I had 20 days to comply or think it over if I wanted a change in job or retire, etc., etc. Well, I asked for Eureka Run 10 o'clock in the morning bid, and that I was hired in 2002, and that I have 200 employees underneath me, and there was work available, and that anybody who works underneath me, I get paid for that day, and it's a 24-hour operation, 24 hours a day, and there's 400 truck drivers there. And I should note that I've been waiting for a phone call or registered mail to return to work, in which they are not complying with the notice of offer of work, and they're not completing their agreement that they made. In other words, they're in violation of their own agreement. So I needed to be enforced by Judge Grill in the settlement conference. I'm waiting for a court date from Modesto Legal Clinic, because we were waiting for a document, to get a legal document stating that I have a severe profound hearing impairment, which states that I had a hearing problem since 2006. And they haven't accommodated me with any listening device or whatsoever since 2006. Okay? So on December 7, 2010, they just flat out sent me home, and they didn't pay me for the day. And I wasn't represented by the union on interrogation by the dispatcher. He told me the shop steward is on his way, and he told me to sit down. And I was supposed to work first and grieve later. It didn't happen. And they just flat out sent me home. And again, I hate to repeat myself, but I have a severe profound hearing impairment. The panel hearing was put in abyss. And I told them, are you an authority on severe profound hearing impairment? And they just flat out sent me home. I had a settlement conference, and Judge Gill was off that day, and Adam Stewart was my attorney, workman comp attorney at the time. The administrative judge suggested that they put me back to work due to the fact that the Safeway attorney was on the phone with Safeway, and Adam Stewart approached me, and my wife was there and asked me how long I could work for. And I thought that was peculiar because I had a notice of offer of work, guaranteed or work for 1 year. Which they didn't comply to. So that was the second time. The first time they violated the time limits in the contract, and they didn't put me back to work like they did for 1,500 other Teamsters. The second time was the administrative judge suggesting that they put me to work, and the Safeway attorney must have told Adam Stewart, I don't know, because when he asked me how long I could work for, and he left, a lady or a secretary came up to us and told us to go to the lunchroom, and then later told us to go home. So that was the second time. The third time, Mr. or Mrs. MORLES, Safeway Private Insurance from Arizona, sent me a letter, or sent my attorney a letter honoring the notice of offer of work, suggesting that I should sign it and send it to Arizona, which I did registered mail in 2013. My attorney, Modesto Legal Clinic, sent me a letter to report to work immediately. I did so. Safeway and the union did not comply, or the union didn't take any action, even though that they were aware of, or I made them aware of, that I had a severe profound hearing impairment to their attorney, and I also sent them a copy of a document of an examination showing and stating with a prescription that I had a severe profound hearing impairment, and they ignored it. In fact, I asked for arbitration, and the union attorney denied it, but suggested or mentioned the fact that we know you have a disability issue and that arbitration is refused and that you could pursue it under workman's comp if you wish to do so. At that point, I figured I exhausted the union system, whatever it is. I exhausted it, and now it's in workman's comp's lap. So at that point, they didn't comply. They put it on workman's comp to comply, so I'm asking workman's comp to enforce the notice of offer of work, and I'm asking for trial because I'm assuming the fact that they're in violation of 2009 Discrimination Act against severe profound hearing impairment or people with hearing impairment, and that the union did not comply with federal law. So I could be wrong or I could be right, I don't know. So, but I'm asking to go to trial so that the judge can make a decision on that for the fact that I've been sitting at home waiting for a phone call or registered mail to report to work since December 7, 2010, and I need a court order to get all back pay and benefits 7 days a week, 14 hours a day, plus my lifetime medical to be restored. Medical, prescription drug, Delta dental, eyeglasses, and I don't know about hearing impairment, and then I'm at 90%. So I don't know what the court wants to do about that, but I'm asking for it to be reinstated. And the fact is, I'd like to make a notation for trial. Add this notation to the recording I just made. And today is Monday, April 22nd, 2013. Just add this recording to the notation I just made for the fact that I should never lose my lifetime medical that I paid for the last 10 years. And the fact that I should have some protection from the court, that whether they retaliate on me or they send me home or quit or fired, whatever, I should have some protection from the court that I don't lose my lifetime medical for life with no premium. I don't pay any premium when I retire. So that should be protected no matter what happens in the future, that I don't lose my lifetime medical, that I'm covered under health and welfare for life, whether I'm working or not. It shouldn't be stopped no matter what, okay? Because I have a disability and I have a hearing impairment, and I paid for that. That's a lifetime medical plan. I should have some protection from the court. So I hope the court can decide on that lifetime medical plan, that they're not allowed to take that away from me no matter what, whether I'm fired or sent home or I quit or no matter what. My lifetime medical plan is to continue on without a break in service. So I'm asking for that. If the court could make a decision on that, I would appreciate it, due to the fact it's a union shop and that they discriminate against me, the union. So I don't know why they didn't accommodate me or anything else and and lost my lifetime medical. It's wrong. I'm asking for some protection and no break in coverage if I should be sent home or they retaliate or I quit, whatever. No break in lifetime medical plan. That it should be continued on for life because I have a permanent disability. That's my notation to be added to the last recording. And I should note that I, Julio Zamora, invoke double standards. Life is not fair. Due to the fact that all disciplinary action was denied on December 17, 2010, because the grievance was received by Teamster Local 439, Mr. Neiswanger, on December 17. It was stamped, received, Local 439, on December 17, 2010. That's more than 10 days. And I should note they didn't respond in 10 days on December 25th, 2010, when they were required to do so according to contractual procedures, and they violated the time limits and also step 1 and step 2 of the contract. And I should also like to note for the record that the fact that any documents or any evidence or statements that's not received by December 26, 2010, not to be valid and not to be accepted by the court due to the fact that they didn't follow contractual procedure or time limits. Due to the fact that they didn't follow contractual procedure or time limits. They didn't produce anything by December 26, 2010. And all issues are dropped. Null and void, final and binding. There are no issues after December 26, 2010. In which they didn't comply and the union didn't enforce contractual procedures, let alone a hearing device or assisted hearing device at the panel hearing, and they put it in a fist and sent me home. So I'm asking to go to trial for the court to get a court order for back pay and benefits and automatic retirement on my birthday on September 7, 2013. And that everything to be restored, back pay and benefits and pension and RSVP. I don't make any payments. It's a premium, lifetime medical. I need that reinstated, and I don't make no premium payments after I retire. None. And I need that reinstated or made whole again, including my pension, my back pay, and health and welfare to be paid. Because my wife is sick and she ended up in the hospital, and it's it's really hard. I have to pay for that bill. So if they could pay for the health and welfare for the year of 2013, I would appreciate it, and then I wouldn't have to make payments to the hospital. And the union put it on Workmen's Comp to resolve these issues. They said I could pursue it under Workmen's Comp, so that's why I'm bringing all that up in the union matter. I'm bringing it up for the fact that they didn't deal with the issues of severe profound hearing impairment, and the fact they didn't deal with the issue, the fact that the dispatcher on December 6, 2010 changed the time on my logs from 10:30 to 11:15, taking the time from the second time clock. I should note that and put me in violation of Department of Transportation and company policy. And he accused me on December 7, 2010 of falsifying documents or intent to falsify documents that he altered or falsified on December 6, 2010. And I should also note that the onboard automatic recording device in the tractor is tamper-proof. Tamper-proof. And you also have to have a key in order to change anything. And the dispatcher is the only one with the key. I'm assuming that's correct because I've seen them change the time on logs before. And I'd like to note also that we get paid by the trip sheet. The trip sheet that belongs to the tractor that prints out logs. I should note that they don't pay delay, they just pay trip miles. Sometimes they pay delay, sometimes they don't. So my point being is the fact that when we log out of that truck, we're off duty. Now, if we log out of that truck, we're off duty, and we're required to clock out in the driver's room and clock in. Why, I don't know, when we're already on duty. The fact is, it's not being recorded, and we're not getting paid by that second time clock. I haven't been paid in the last 10 years, myself or 400 other truck drivers. I should note that the time clock in the driver's room, we're required to clock out. When we log out of that truck, we're still on duty according to company policy or instructed to do so, myself and 400 other truck drivers. When we're logged out of that tractor, we're not allowed to go home. We have to clock out of and check in the driver's room and clock out, and there's no time card. We don't get paid by the hour when we should be getting paid by the hour for services rendered, but we're not. And I was sent home on December 7, 2010, and I didn't get paid for that day, and there's no time card. In fact, there's not even a trip sheet for that day. What happened to it, where it went, I don't know. But in any event, I should get all back pay. There's no doubt about it. Okay, and the dispatcher is guilty beyond a reasonable doubt because he altered my logs by taking the time off the second time clock and changing the time on my logs, which is not required to do so or has the authority to do so according to Department of Transportation Regulation 395.15, 395.16, and 395.8. He's not allowed to alter or change anything on them logs. And if he is, he's supposed to make the driver aware that he did so. And he didn't make me aware on December 7, 2010, what he did on December 6, 2010. And again, I was not fired on December 6, 2010 or December 7, 2010, for the record. Or corrected him, whatever the case is. I don't know what authority they have on changing logs. Under the Department of Transportation 395.15, 395.16, and the interpretation in 395.8, it states in there that they're not allowed to alter or change anything on them logs. If there's a problem, there's a right in the remark section what the problem is. And what the problem is, and make the driver aware. They didn't do so on December 7, 2010. And so I should note for the record that they didn't honor the notice of offer of work at least 3 times. They denied to put me back to work. And that I have a permanent disability according to the QME report. And that it states in there that I can do my customary duties on my job. And I should also note that according to the legal document that I have that was requested by Judge Grill in the settlement conference to 2 attorneys that I just received, that I have a severe profound hearing impairment since 2006, and that I lip read. I'm not good at it yet, but I'm learning, and I'm also trying to learn sign language. But the point is, I've never been accommodated at any time since 2006, and they need to accommodate me with hearing aids because I bought my own, and they're old, and they don't work at all. And I need something that blocks out background noise and stuff like that from the reaper. So again, I'm asking for a court order to be returned to work, all back pay and benefits, and health and welfare, and my lifetime medical, according to the 2009 Disability Act, and also to the contract, okay? Because I didn't do nothing wrong on December 7, 2010. The only thing I received was a notice of offer of work, and they just flat out sent me home, and I was also on FMLA. So this is my request for trial, for Judge Bill to consider sending this case to trial to resolve the issues of the Disability Act of 2009, hearing impairment. I would appreciate it if we did that, and I also would appreciate the fact that he enforced the notice of offer of work and return me to work according to the contract. And I would appreciate that. And I should point out that the fact is that they've been refusing me, denying me medical treatments. I don't get paid every week or every 2 weeks since 3/21/2009 or 4/17/2009. They refuse me to put me back to work when I have a full duty release to go to work. They won't accommodate me with hearing aids. They won't honor the notice of offer of work. I hate to keep repeating myself, but I do have a severe profound hearing impairment, and my life is on the line. And I need the notice of offer of work to be enforced for the fact that my daughter needs 1 more year at the university to get her BA in biology. 1 more year. I need that 1 more year. And they made an agreement with Workmen's Comp to work me that 1 year. And I'm asking for it to be enforced so that my daughter can finish at the university. And that was a guarantee for 1 year. And I didn't start 1 day on the 10 o'clock shift Eureka run. So I'm asking Judge Bill to consider that. And I'm also asking him to consider the fact that a double standard is the application of different sets of principles for familiar situations, or 2 different people in the same situation. A double standard may take the form of an instance in which certain concepts, often, for example, a word, phrase, social norm, or rule, are perceived as acceptable to be applied by one group of people, but are considered unacceptable, taboo, when applied by another group. The concept of double standard has long been applied, as early as 1872, to different moral structures on men versus women. A double standard, thus, can be described as a sort of biased, morally unfair suspension towards a certain group of the principle that all are equal in their freedoms. Such double standards are seen as unjustified because they violate a basic maxim of modern legal jurisprudence that all parties should stand equal before the law. Double standards also violate the principle of justice, known as impartiality, which is based on the assumption that the same standard should be applied to all people without regard to subjective bias or favoritism based on social class, rank, ethnicity, gender, religion, sexual orientation, age, or other distinctions. A double standard violates this principle by holding different people accountable according to different standards. The phrase "life is not fair" may be invoked in order to mollify concerns over double standards. I'm hoping that Judge Gill considers this statement for the fact that if the company doesn't comply with the time limits under the contract, 1,500 Teamsters are returned to work immediately. Well, they didn't put me back to work. And James Williams, our transportation manager, knows all this. He knows everything. He knows what's going on. But he didn't comply. He didn't put me to work, back to work like they do for 1,500 Teamsters or 400 truck drivers. I should note that for the record. And I should also note for the record that they didn't accommodate me with any listening device whatsoever since 2006. So I'm asking Judge Grill to consider this and to enforce a notice of offer of work because my life is on the line here and I have no lifetime medical. I have no medical coverage whatsoever, even though I paid for it in 2002. I paid $3,000 plus to cover for 5 years so that I could retire at any time. And I should also note to the fact that Safeway called to health and welfare and said I didn't work at Safeway. And that barred me from getting any kind of lifetime medical or asking them to keep me covered. That didn't happen. So, and the fact that the dispatcher who falsified my log by taking the time off the second time clock, and they have a no-fault attendance policy, and they applied it to everybody else, but they didn't apply it to me. No-fault attendance policy that's been as part of the company policy for 10 years that I've been there, and from my understanding, it's been on there for at least 20 years. No-fault attendance policy. So, and the fact that I never received any registered mail or anything else stating that I didn't work at Safeway at any time, not within the time limits, okay? So, and the fact that they just flat out sent me home, and they didn't pay me on December 7, 2010. He took my time card or my trip sheet or whatever it is and disposed of it. I don't know where it went, it disappeared. And I never got paid for that day. So that's why I'm asking for back pay from December 7, 2010. And I hope Judge Gill considers again to enforce a notice of offer of work and that to send this case to trial. And I hope he considers this seriously for the fact that I have a hearing impairment and that the union should be held responsible under the Disability Act of 2009. And that's my statement for the court. So I hope Judge Bill considers the double standards.
I should like to note one thing, that I stand to be corrected by my statements and everything due to the fact that I have a notice of offer of work that I received on December 1st, 2010. Mike Sadler and James Williams are well aware of the fact that I have a notice of offer of work that I'm guaranteed for 1 year, and they refuse to comply. And I'm sitting here waiting for a phone call or registered mail to report to work, and they refuse to do so. And I should also like to note for the record that any statements or documents that's not handed in before December 26, 2010 should not be accepted by the court. Because anything not sent in by December 26, 2010, okay, is null and void, final and binding, and all issues are dropped. And James Williams and Mike Sadler of the Safety Department and James Williams of the Transportation Department, the manager, knows all this. But it doesn't matter. They refuse to put me to work. They refuse to comply with contractual procedure or workman's comp rules and regulations. Now, again, I repeat myself. I stand to be corrected, but I'm asking the judge not to accept any documents that's not dated before December 26, 2010. And I hope he considers double standards. I, Julio Zamora, invoke double standards. Life is not fair.